right, good morning, everyone. Welcome to today's webinar. This Google versus Oracle, fair use and copyright through the lens of the most recent Supreme Court case. We got a lot to talk about. It's going to be very exciting. My name is John Hovey. I'm with the North Metro Small Business Development Center. I'm the Special Projects Coordinator. If it ain't special, I don't coordinate it. And I'm here today with Samantha Peasley, attorney at law, representing Polaris Law Group. And wow, if you haven't been to one of our programs before and you don't know what we do, the SBDC is here to support small businesses. We offer free one-on-one consulting services, and you can book those through our website at any time. It's northmetrosbdc.com. You can click request initial appointment, and we'll pair you up with a skilled business expert who can help you with anything from writing a business plan to legal questions like this. So check that out. And we also offer free and low-cost training programs as well. And at our website, you can see a complete schedule of all of our upcoming programming too. Very exciting things coming up. Today, we're talking about fair use, copyright, and things like this. I know that's a very interesting subject for a lot of our small business owners. They want to protect their own intellectual property and sometimes to, access video and audio and other images for use with marketing and things like this. So I'm sure this will be in demand. We encourage you to ask questions throughout the presentation, and we have muted your microphone so that the webinar streams nice and smooth for everyone, but you have a question box in the right side of your screen. There's a GoToWebinar control panel. Please type in questions at any point and we will answer them. We'll also save some space at the end for a question and answer period. If you, want to save your question till the end, that's fine. Finally, I'll be recording this and sending you a video copy a little bit later today, and I'll make sure to put some notes and contact information for Samantha and Polaris Law Group and everything, so you can find us and keep this relationship going. So once again, thank you for attending. And Sam, thanks for being here today.
Absolutely. Thanks, John. And thanks for that great intro. This is always a topic that I'm very excited about. And you guys today are lucky. This is the first presentation I'm doing on this brand new Supreme Court case. So we're going to be doing a little bit of a spin on my normal fair use presentation to really look at what has happened in this most recent ruling from the Supreme Court and how this is going to affect us. So yay, so happy to have you guys all here today for that with us. As John said, type in questions as you're going. I'll probably take some little breaks at places that are good for stopping and just ask if we have any. But like John said, we also have them at the end. I do always caution with some of these, if you have a personal question, something about how something personally affects your business, I may tell you that if you ask it, that would be better for a one-on-one consultation. If you have something that can be framed where it's helpful for the whole group, I always like taking those questions. I will do my best with it. But if we get too down and dirty into a particular area, I'll probably say, and that is what your great SBDC consultations are for. Let's take that offline and dig deeper into that. So not trying to stop people from engaging with that, just want to make sure that we're getting the generally applicable stuff today. So given that, let's dig deep into Google v. Oracle and what this most recent Supreme Court case tells us about fair use and copyright. So I'm going to start out a little bit just with giving you guys the background of the case so you know what we're talking about. Obviously, this is not going to be generally applicable for everybody, but it can be a little bit helpful in understanding what we're talking about today. So, Google v. Oracle, we know those names, right? Those are big companies there. Oracle America Inc. owns the copyright in a program called Java SE. Java SE is a program that uses their popular Java computer programming language. Oracle used to be, or was acquired Sun, who was the original writer of this, but Sun Java, they're well known with programmers throughout with the programming language, and Java SE is designed to be an interoperable program, meaning it works on all sorts of different computers so that Java programmers can then utilize it more readily so that people aren't stuck with a single one. So at some point in 2010, Google acquired Android. A lot of acquisitions in these big cases like this, and you'll often find that parties will switch over from time to time. So sometime after acquiring Android, Google went to go talk to Oracle, at that point Sun, and said, hey, can we license Java SE for our new Android platform? But Oracle had some basic requirements that Google didn't want to follow because they wanted everybody to be able to use Android programming, as far as that goes. By the way, very funny, my phone keeps lighting up thinking that I'm trying to talk to Google on this one. So if anybody needs to put their phone outside of reach as I'm giving this presentation, feel free to do so because we're going to be saying the name a lot. So Google decided not to license Java SE for its Android applications, but to design its own program. Roughly 100 Google engineers worked for 3 years to do this. And in doing so, Google did copy a portion of the Java SE without permission for use on them. So they didn't try and go back and get a partial license. They mostly wrote their own program, but copied this portion of it. They copied roughly 11,500 lines of code. All of those copied lines of code are part of something called the Application Programming Interface. By the way, I apologize to any programmers on the line. I'm going to be doing the best I can with this, but there are going to be some times where I am speaking in a very oversimplified manner as far as this goes. So feel free to correct me on anything crucial that you're running into, or maybe just tune me out for while I'm trying to explain programming. So API is a tool that allows programmers to use pre-written code to build certain functions in their own programs, rather than to write their own code to perform those functions from scratch. So we break those down then into each task as a method. Similar methods are grouped into classes. Similar classes are grouped into packages. So for example, a compare 2 and 3 and determine which is bigger is a method. Those methods might go into the class of math. The math class might go into a series of package. I'm not sure what the larger package on that one would be, but you get the general idea with that. And I'm about to have a more thorough example. So within this, we have our API. So our big tool that allows the programmers to function with those methods, classes, and packages. So then breaking it down, top level, we have something called implementing code. That's what tells the computer how to perform each task. That is what the coders are writing as far as that goes, very descriptive. Underneath the implementing code is you have something called method calls. A method call is a command that tells the computer which implementing code to go get. It tells them to go, hey, go get the how to compare two numbers. The declaring code is then that part of the API that tells them where that method, in which class, in which package that code is. So the way that Justice Breyer described this in the Google case is it's kind of like the gas pedal. The declaring code is like the gas pedal. In and of itself, it does nothing. But when you press down on it with your foot, when everything is functioning properly, it sends a signal to the car to increase the amount of gas that you're using, which increases the speed of the car. Similarly, QWERTY key on your keyboard, the key itself, the little piece of plastic, does nothing. But when you press it down, it sends a signal to the computer that brings up the letter that you want. So it serves both as that interface as well as the organizational system. So you have that declaring code at the bottom, the method calls, the implementing code. Let me give you an example because this is very helpful in this one. So the example of a declaring code applied to a library. Let's say that you have a robot librarian. We're going to give a robot librarian because robot librarians, unlike regular librarians, understand only very simple basic commands. So your robot librarian is kind of like your API. That's your tool, that's your program. You tell the robot librarian, find TTOTS. You just happen to know that that's the code. Find TTOTS. That phrase, that command, is the declaring code. Find this thing. When the robot hears that declaring code, it knows that it needs to go get Taming of the Shrew, which is the method call. That's the full play. It's the book. It's a lot of instructions in there that it needs in Shakespeare, which is the class where it's found, which is in the genre section plays, which is the package. So you see package plays, break that down into Shakespeare plays, break that down specifically into the Taming of the Shrew, which is the play, which has all of your instructions. The robot retrieves the Taming of the Shrew and brings it back to you because you use that declaring code to go get that method. You now have the method call, which is the instructions for how to perform the Taming of the Shrew. We've seen this like to recipes or to instructions. Here it's a play, it's a full written play. It's a script. But then how you choose to perform the script is the implementing code. It is your personal touch, it is your interpretation of it. So hopefully you can understand with that how broken down that is and how we kind of get more creative to less creative implementing code down to that declaring code, which becomes important. We have those kinds of breakdowns in a lot of copyrightable materials. So for example, if it is an actual recipe is going to be a little bit more instructional, a little less creative than Taming of the Shrew. We see this a lot in architecture. You're going to have some portions of the architecture that are fanciful, creative, and beautiful, and others that are going to be more of a focus on the utility of the case. So understanding this breakdown is going to help you understand what we're kind of going into a little bit more. So in this case, Google wrote its own implementing code. It did its own performance of Taming of the Shrew. Maybe it did it 10 Things I Hate About You style with some Heath Ledger in there. Maybe it did it more classic Broadway. Maybe it did it Kiss Me Kate. Maybe it did it very classic Shakespeare. Either way, what we know is Google did its own performance. It wrote its own implementing code. For most of the Android API, Google also wrote its own declaring code. Remember, that was the statement that said find TTOTS, missed a T in there. But for 37 packages, so think the genre play, the genre novel, the genre self-help, the genre sports, 37 of those packages, Google copied the declaring code, those single instructions, from Oracle's API. That included everything down in there. So if you're plays, you're not just Shakespeare, but you're also going to be Tennessee Williams. You're going to be any of those kinds of plays that you have within that, as well as their groupings and their method calls. So that's also going to be the complete works of William Shakespeare and the complete works of Tennessee Williams. Google's copying allowed its programmers to use the same task calling system that they had already learned by learning Java, which is why they did that. They did it for simple things that their programmers would already know. That's the basic facts of the case, very much summarized. So I just want to stop there real quick and see if we have any questions. Besides Sam, I came to learn about fair use. Why are you teaching me about programming?
So far, this is very interesting. One of our participants here, Kevin, has a few questions, but I think I want to answer them a little bit later just so that we can not lose the facts of the case.
Awesome.
Yeah. Does anybody else have any? You can type them in now. If I see any, I'll let you know, but I think we're good.
Perfect. Okay, so that's kind of our basic facts going forward. Like I said, I wanted to give you that idea because it can be really helpful in understanding what the law is on this. The procedural history, I'm just going to give you really briefly to show you a little bit how these kinds of cases can go. So Oracle sued Google in 2010 in the Northern District of California. But Sam, you said this was a brand new case. It is. So that was the original case. Sued them in Northern District of California for both copyright infringement and patent infringement. And we're going to come back to that when we talk a little bit about copyrightability. But I want you to be aware, copyright and patent, both. Jury found for Google on the patent, say no infringement, found limited copyright protection for Oracle, and then deadlocked on Google's fair use defense. So the jury said, we think there's some copyright protection, therefore we think there's some fair infringement, but we don't know on fair use. The judge overturned the jury decision on copyrightability, meaning that they said they didn't think the API was copyrightable in the first place. Judges can do that on certain issues. We're going to talk about some of the difference between the decisions based on fact, decisions based on law. Whether something falls within copyright protection is something that the court can overturn as a matter of law. So the judge in that case did. They said, look, the declaring code is not copyrightable. The system or method of operation is not copyrightable under the law, which is a good statement of the law. A system or a method of operation is not copyrightable. That's why you sometimes have those patents and copyrights together for software specifically. Federal Circuit, so they appealed. Federal Circuit held that the judge was wrong. It was copyrightable in this circumstance, and that they didn't have enough facts to determine the fair use question, so the jury needed to go back and hear those facts again and make some fact determinations. Okay, Google at that point appealed, and the Supreme Court said, nope, not enough information yet. Okay, so it kicks it back down to the jury. So then the jury goes back and looks at that issue again on fair use only. You can have a trial on limited questions. And after a 5-day jury trial and 3 days of deliberation, the jury decided that Google did show fair use. So they infringed, but that it was a fair use, so they had a defense. Federal Circuit reversed it. They said, oh, here's the facts that the jury found. We're going to assume them all in Google's favor. We're going to assume that the jury was right on these findings of facts, but we think the jury was wrong as a matter of law. And since fair use is part fact, part law, we're going to switch the holding. And then they sent it back down for a trial on damages. At this point, the Supreme Court granted cert is what we tend to say, partially because I can't say certorial. I can never say that right. Meaning the Supreme Court said, we'll hear this decision now. We think that there are some legitimate issues here. And they heard argument, and then this written decision came down April 5th, 2021 as a 6-2 decision. Justice Barrett was not part of the decision because she had not heard oral argument on this issue. The majority was written by Justice Breyer. The dissent was written by Justice Thomas. Freely available to find on the internet if you want to. I'm giving you the highlights here today. But so that procedure just kind of shows you a little bit of that up, down, up, down, up, down, as well as kind of what that process looks like. So the legal questions before the court are two of the most basic legal questions in copyright, which is great. We're only missing one of the big three. So the first one is, could Oracle copyright the portion of the Java SE, which is a program that Google copied, AKA, was that portion of the computer program copyrightable? Was it something that can be protected by copyright law? We skip what is usually the second question of, is there infringement? Usually that comes afterwards. In this case, it didn't, and we'll get to that. But then if it was copyrightable and if there was infringement, was Google's copying fair use of that material, which would free Google from copyright liability? So we usually do this in this way because you can't jump straight to fair use. Justice Breyer seems unaware of that issue, but typically you can't jump straight to fair use. I'm going to be a little unfair to Justice Breyer in this at some points. He writes a very good opinion. It is very easy to understand, but there are some things that are very frustrating in this case to copyright attorneys, to long practicing copyright attorneys. And one of these is that he skipped these other questions, but these were the two questions on which the court granted cert. So that's a jump into copyrightability. Coming back, any questions so far? Good.
No questions.
Nope. Cool. Thanks, John.
I'm hoping we can take a poll of where people think, because we haven't announced who won the case, did we?
I don't think so yet.
Type in your best guess, folks.
Yeah, absolutely. And now some of you may know this was a pretty big case. So especially any software developers might have seen what happened here, but absolutely type in your best guess. It will be interesting to see, based on, you have the facts, you have the procedure, so you know where it goes up to here. All you're missing is the law and then the justice's legal analysis. So feel free to make some good guesses here. So I'm going to walk through these questions one by one, and I'm going to give you both what general copyright law says and then kind of how this case handled it in this instance. So I'm going to broaden us out a little bit and then focus us back on the case. for each of these issues. So first, copyrightability. Very basic first thing that we do. Can I copyright this? To be copyrightable, something has to be an original work of authorship fixed in a tangible medium of expression. If you take nothing out of this presentation, remember that to be copyrightable, something must be an original work of authorship fixed in a tangible medium of expression. So remember we said earlier, systems and processes, methods of operation are not copyrightable because those are not considered an original work of authorship. Facts are not an original work of authorship. However, the expression of those facts and how those facts are conveyed may be copyrightable. So it's a balancing test. And this is part of why whether something is copyrightable is often a question of law. So it is a question for the judge. There is a statutory list of what those can be, including literary works. The Copyright Act has 12 categories of things that can be copyrightable. They include literary works, performances, audiovisual works, music compositions, I said performances, architectural works, like I said, a number of things, most into those categories. It is law since about the 80s that code and computer programs fit into the category of literary works. So they default into that statutory list as literary works. So typically you do want to be in that list somewhere. And then within that list, you want to be an original work of authorship fixed in a tangible medium of expression. And you cannot be an idea, process, procedure, system, method of operation, concept, principle, or discovery. That's in the statute. So remember I said earlier, recipes typically have very thin copyright. That's true. Recipes are just processes. They often are not copyrightable. Sometimes they might be, but if you've ever gone online and looked for a recipe and said, oh goodness, why does this have 7 pages of story before I get down to the recipe? It's partially to make the page copyrightable. It's partially to make the page better found also from a marketing perspective, but also that recipe itself is going to have very thin copyright, if any. And however, the story will make the blog as a whole copyrightable. So,
clarifying question from Olga. Hi, Olga. Thanks for being on. Engineering drawings, copyrightable?
Excellent. Yes, engineering drawings and blueprints. That is one of the categories I forgot. Copyrightable by law. But they're going to be split a little bit. Could segue, Olga, into copyrightable and uncopyrightable portions. So you remember in this, we were saying, okay, we have the declaring code that's copied. That's not the entire API. It's a portion of the API. That's very common in some of these things that are useful, but also creative. Engineering drawings and blueprints being one of those, CAD drawings, and any of those frameworks there are copyrightable, are protectable, but there may be portions of them that are less so, portions of them that are more so. So typically, if we're going through a process of looking at a work, we will walk through the series of questions in this order. So first, does it fall into a statutory category? Blueprint drawings, engineering drawings do fall into the statutory category. Is it an original work of authorship? We're going to assume yes. Let's assume that we have some engineering drawings for this new office building downtown and that it's fantastic and it's original. Now, this is where sometimes you'll then break that down. So compilation objects or objects that are facts but are an arrangement, a unique arrangement, selection, and coordination of non-original elements will get protection, but it's going to be thin, meaning that you pretty much have to have very strict copying, not something a little bit similar. What do I mean by compilation? If you're putting together an images book, photo book, with a bunch of other authors' photos, that's going to be a compilation. Each of those photos has individual copyright protection. The book itself will then be a compilation work, similar with a book of short stories. Arrangement, selection, coordination, that comes up a lot in architecture and engineering. So if you have something like a house, the plans for a house are protected. However, the fact that your mudroom is at the entrance is probably not going to be protected because that's not a unique and original arrangement or selection of those elements. The fact that your kitchen, that you have a kitchen and a living room is not going, those are going to be unprotectable elements. So the thing that is protected is the unique movement around how you choose to put those pieces together, to the extent that it's not purely for useful elements. So in code, which is what our case is about, you're going to have something a little bit that, are you just arranging and selecting those call signs in a new way? Are those call signs really something that are unique, or are they there just for a useful function? And that was kind of where those courts were starting to go back and forth on that. So you see that in a lot of copyrights that are useful, but also create original works of authorship. You see this less in things such as a painting or a sculpture, or pure literature. So then we go next, is it fixed in a tangible medium of expression? Ideas are not copyrightable. Second thing that you should take out of this, ideas are not copyrightable, period. If it was just in your head, it's not a copyright yet. Similarly, if you played a performance and you never recorded it, that's not a tangible medium of expression. Or you didn't write it down on sheet music. Are the elements, and then you break it down to, are the elements in question protectable? So we do those first three to figure out if the whole is protectable, and then are the individual elements in question protectable? For example, in a book, is the table of contents protectable? Ooh, that's really going to depend on how creative those titles are. Table of contents is there for the useful purpose of letting you find your page. So even though the book as a whole might be protectable, table of contents might have very thin protection. We're talking about the engineering drawings, about the house. This is where we look at that protection. We use something called the abstraction filtration comparison test, meaning that we break everything into tiny parts, we filter out the things that are purely useful, and then we compare what's left. So that is how we kind of look at those individual elements. And then we kind of, when we compare them and put them back together, we look and see whether those protectable elements are a substantial part of the whole work, substantial in volume or substantial in importance. That's how we usually determine whether something is copyrightable. So based on this, in Google versus Oracle, we're looking at this 11,500 lines of declaring code. So remember, the most basic level here, not the method calls, not the implementing code, the declaring code. Does the declaring code fall into a statutory category? Yes. Is it an original work of authorship by Oracle? Arguably, yes. You know, we would say yes, but that this is really very functional, so that this might just get thin protection because you're really determining how to select and arrange facts. You're really figuring out creative ways to say, go find the taming of the shrew. It's going to be thin as far as that goes. Is it fixed in a tangible medium of expression? Yes, it's in the Java SE. And then, are the elements in question protectable? That's when we come down. Are these individual method calls? Is this individual declaring code protectable? You would typically do the abstraction filtration comparison test, filter out the things that are purely useful, compare the things that are left. Are they a substantial part of the whole? It's kind of a subjective question. That's often what we're kind of looking at the jury to take a look at, is how substantial is this? That's how we would usually do this. Based on this, you know, that's my best guess. Obviously, differing minds or different minds can have different results. As I like to say, sometimes the danger with copyright is you ask 10 attorneys, you get 10 different answers. But I think in this case, we're probably looking at something that is copyrightable. Obviously, the API as a whole is going to be copyrightable, but that the declaring code itself is probably going to have thin copyright protection. Okay, that's my assessment. Any guesses on what the court said? Court punted. Supreme Court punted. Supreme Court said, given the rapidly changing technological, economic, and business-related circumstance, we believe we should not answer more than is necessary to resolve the parties' dispute. We shall assume purely for argument's sake that this is copyrightable. We shall ask whether Google's use of part of that API was fair use. Now, it's okay that they did this from a legal standpoint. Why? Because the Federal Circuit below had determined what I just said. The Federal Circuit below had determined that this was copyrightable and that it was thin copyright. The frustrating thing from the attorney perspective is that instead of the Supreme Court justice saying, we just agree with the Federal Circuit's analysis, that they said, we're just not going to decide it. So frustrating for a lot of software copyright attorneys, frustrating for a lot of software developers, because we don't technically know the answer from the Supreme Court on this yet. They just assumed it. And one of the big things on the dissent was copyright law says copyrightability, infringement, fair use. You can't just skip this. However, court can do what it wants, and it did skip it. So what we are determining here is that the Federal Circuit's decision stands and that there is copyright in things such as the declaring code, but that it is likely a thin copyright. So then we go to the second question of infringement, which is when a copyright holder's exclusive rights are violated. The Copyright Act has a list of 6 exclusive rights to a copyright holder that include, I just included the big 3 here, copying of that work, makes sense, distribution of that work, so think of the selling bootlegged DVDs on the streets in China, and creating derivative works, meaning creating something new in a new medium from the copyrightable work. So typically that means that you're taking something and changing it. An example I like to use a lot is Beauty and the Beast, the original story, the Disney movie 1990, Disney Beauty and the Beast is a derivative work of the original fairy tale. The more recent human reenaction, or the Emma Watson version of that one, is a derivative work of the original Disney. Actually, there's a musical in the middle there too that is a derivative work of the Disney musical. So that derivative works is taking it, changing it, making your own copyrightable work, but using core elements of the original copyright. Those are the exclusive right of the copyright holder. If you do one of those things without permission, keywords there, without permission, that is infringement. Typically, we test this if people are saying we didn't infringe by 2 factors, access and substantial similarity. Okay, so did somebody have access to something, and then are the 2 results substantially similar? Here, we know that Google had 100 Java programmers, so there was access. Everybody who was working on this had worked with Java SE before. We also knew that Google had considered licensing it. And then substantial similarity, it's 11,500 lines are exact copies. So we've got the access and substantial similarity of here. And it can be of elements. So the fact that they direct copied 11,500 lines plays into that. It doesn't matter that they didn't copy the full API or even the full Java SE. You can break this down into elements. But if protection is thin, we were talking earlier about thin copyright protection, you're gonna need almost identical copying as far as that goes, or distribution that is not permitted. So if you do have, let's say, the architectural designs of a house, and houses typically do get thin protection because you have those functional elements in there. If it is just a house, it's just the designs, there's nothing super creative or funky going on in there, you can't then go to another builder and say, hey, your house also has 2 bedrooms, 2 bathrooms, a kitchen, and then this big floor layout. You copied me. Your protection is going to be thin. You're going to need an almost exact copy of the blueprint in order to get that on that. Whereas creative works are going to get a lot more freedom on that. You're going to be looking at substantial similarity from a much broader perspective. So that's how we typically determine infringement. Why did the court skip infringement here? This is not a problem of the court. This is very common in cases like this. And the answer is very, very simple. Google admitted it copied it. Awesome. Google admitted that it copied the 11,500 lines. End of story. We don't even need to discuss it. So then, if it's copyrightable, that's infringement. Google was not arguing that it didn't copy it, that no, we made up these 11,500 lines from scratch with 100 Java programmers. Totally. Not at issue in this case. So you'll see this a lot in some of these big copyright cases, is that there isn't actually a question on infringement. So we do in fact skip the question, even though it is technically that second step. Typically the court will just give it lip service with 1 or 2 sentences. Here it didn't. That's not really that big of a deal. Google admitted it copied it. So if Oracle's code is copyrightable, which Google claims it was not, or Google claimed the declaring code was not, then Google did infringe. So then that leads to the next question. But was it okay? Fair use is a defense to infringement. That means it's not something you bring up at the outset. You have to have infringed before fair use comes into play. So what do we typically recommend from the attorney perspective for small businesses? Any guesses? I said this in infringement, one of those key issues in infringement. We recommend that you get permission. Because if you have permission, it's not infringement. You don't need to go to fair use. Way easier to prove permission than it is to prove fair use. Much fewer questions on that. So usually we say, try not to get to fair use in the first place. Let's not get there. Let's stop it at infringement. So you have a copyrightable issue, you have a copyrightable subject matter, you have infringement, so then you're going to assert fair use as a defense. So this is within the Copyright Act itself. It started with judges, but then Congress put it into the Copyright Act later to determine that there is a really reasonable purpose within the US for fair use. Fair use is not in every country with copyright laws. It's context-based, it's subjective, but basically when we say, well, that's a really important purpose for us to allow somebody to use somebody else's copyright, we allow it. So some of the stated reasons that we allow it are for criticism, comment, news reporting, teaching scholarship. Teaching scholarship being a very important, there's a couple of words missing, but it is basically teaching scholarship, not teaching like I'm doing today, or research. That those aren't going to be an infringement of copyright. We like those purposes. Now you can push those bounds a little bit, but typically we have some purposes that we want to use fair use for. Before I jump into the factors, I am going to ask if we have any questions on that copyrightability and infringement.
We do have one. Olga asks, and you touched on it a little bit, but maybe just to make sure we addressed it for her, about international protection. Is copywriting international or just for a particular country?
Oh, great question. No, copywriting is country by country, use by use. We do have something called the Berne Convention, that allows you to extend US copyright protection to another country based on your US use, but it is geographically located. So if you are wanting your US copyright protected in France, you're going to have to file an application to get that protected in France. If you are, and then you may have some slightly different rights in France. Good question though. Any other ones?
Well, since you brought up permission, this is maybe a good time to look at Kevin's question from earlier.
Great.
He says, I make music performance videos. Can I include clips from YouTube and other sources in my videos? Where should I show credits? During the clip, at the end? Any guidance for best methods?
Cool. So this is one of those ones that I'm going to answer a little bit, but is also going to be a feel free to set up a consult with me as far as that goes. First thing I'm going to say is do not confuse credit with permission. That is a very common issue that we run into with small businesses, is they think that because they put where they got it from on Google that it's okay to use. That is not permission. That does not make it okay to use. You will get slapped with an infringement suit so fast. So I'm going to assume that you have the permission and then are also giving credit. Typically, you want it to be as close to the work as possible. We typically recommend both on the page and then in the actual videos for absolute safest practices. But if you want to talk to me, Kevin, about that offline, I'm happy to kind of walk through that a little bit more with you. But
Excellent.
really glad we got to address the credit versus permission aspect.
That's great. Jackie votes that Oracle wins, by the way. Let's see, Jackie.
Awesome. That Oracle wins, but what?
I said, well, let's just see.
Let's see. Jackie votes Oracle wins. Good vote. All right. So we're going to talk into the 4 factors of fair use, and this is where the vast majority of the court's decision was, and why most of you are here today. So the 4 factors of fair use. Key point here, in legal language, element means each thing must be proved. Elements are all ands. Factors mean that things are considered and balanced against each other. So that doesn't mean you need to get a checkbox for each one of these, but that these are going to be weighed together and balanced. Different judges are going to weigh each of these a little bit more seriously. So important to consider all of them. The first factor is the purpose and character of the use. For example, whether it's commercial, nonprofit, educational, these are typically what we see in that statutory language that I quoted. Second, the nature of the copyrighted work. Oh, and sorry, the first one goes to the infringing work. Second one goes to the copyrighted work. So we're flipping back and forth on those. So the nature of the copyrighted work, what was it? Was it fiction? Was it nonfiction? Was it closer to a method? Was it more creative? We look at those things. Then we look at the amount and substantiality of the portion used in relation to the copyrighted work as a whole. We get into that math. We look into the math, but also the heart of something. And then the effect of the use on the potential market for or value of the copyrighted work. How is this going to harm or help the copyrighted work? So we look at all 4 of those things. And true to that, in this case, the judge also looked at, the justices also looked at all of these things. But first, they jumped to the copyrighted work. They put the copyrighted work first. There's a lot of dispute about whether that was the appropriate thing to do or not. It's not traditional, but there have been scholars before that say you should, in fact, look at the copyrighted work before the infringing work. I think it's a personal preference. So typically we're looking at this and we're looking at things like fiction versus nonfiction, academic versus, creative. Is this for sale? Is this for the purpose of art? So we take a look at that nature of the copyrighted work. So here we're looking at Oracle's API encode. The API is what was the copyrighted work here. And then we can break it down even more to that declaring code, which the court explained as the user interface. There's some debate as to whether you look at the API as a whole or the declaring code specifically, but there's not a strong answer here. And so here the court kind of went back and forth between one and the other, but really focused on that declaring code, really focused on that find TTOTS, find the taming of the shrew. That's the part they're looking at. So we're seeing that, well, it is a part of a program, so it is subject to copyright. Typically, we would have done that in the copyrightability, but here we're just doing fair use, so they're looking at that. And that, is it thin or strong copyright? And this is often where that matters. The nature of the copyrighted work, how strong is it? Here, if it's inextricably bound to a system, we're going to consider that pretty thin often. So that if something is pretty thin copyright, that if it is, well, it's really hard to pull apart that original work of authorship from those uncopyrightable ideas and methods, that's going to get less protection. We also look at whether it is user-centered or innovative, and that's something that the court looked at. How much of this was the creative work versus how much of this was there for the practical matter? Here, what they decided was that that implementing code was very innovative and exceptionally creative, and they had a lot of testimony on that. But that the declaring code was entirely user-centered. It was to make it easy for programmers to design things for the Android platform. That made a big difference. What also made a big difference, and this kind of goes into that thin versus strong copyright, is how original was it? How many chains go back? And here there was a lot of testimony on how Oracle used pre-existing API in creating its API. So this wasn't even Oracle's original API. They had the copyright in it, but that didn't mean it was entirely their original work. That can make a difference, especially if that original author, original license holder doesn't come forward. So here that was found to be pretty thin as well. And then it is inextricably tied into that implementing code. That didn't seem to make a factor in the decision, although oftentimes it will be, because especially if it's unique to both, they're not really supposed to look at unique to both here. They're just supposed to look at Oracle, but they did say, look, this matters because it is tied directly into that implementing code. So based on how thin this protection was, based on the fact that it was very user-centered, and based on that fact with the pre-existing API, the court found that this factor weighed in favor of fair use, weighed for fair use, meaning this is going to help Google. So then they're going to look at that second one, purpose and character of the use. Purpose and character of the use, now we're looking at Google's API. We're looking at what Google did. One of the most common questions here is whether it is a nonprofit versus commercial use. I will tell you that it doesn't typically matter if it's a commercial use, they'll just keep going through the factor. If it's a nonprofit use, that weighs very heavily for someone. Now, in small business world, this is a very common mix-up. People say, well, I'm just using it for my blog. I'm not actually getting services from it. I'm not actually getting paid for it. Well, but is traffic coming to your site as a result of that blog? Is the blog on your business site? Are you doing it to show your expertise so that you get business? That's a commercial use, not a nonprofit use. So those lines can get a little bit tricky for small businesses sometimes. However, I think we can all agree that Google did not create Android for purely nonprofit purposes. Easy one for us to look at as far as that goes. But the court kind of skipped the nonprofit versus commercial. Like I said, it's not always there. The court instead focused on this transformative thing, which is, does it add something new with a further purpose or different character, altering the copyright work with new expression, meaning, or message? This is fairly new, because basically what the court is asking is, does it create a derivative work? And there's been already a little bit of backlash on this particular aspect for the purpose and character of the use. You know, what we usually see, and what they discussed a little bit, was, does it fulfill the objective of copyright to stimulate useful works, creativity, or public discourse? For example, parody often will have to do direct copies of things in order to be able to make fun of the thing that it makes fun of. We like parody. Criticism will often purely copy something in order to say what they think about it, and that's free speech, that's expression, that is you know, making sure that things are held in check. So we like that. And here they looked at whether that fulfilled the objective of copyright. And they kind of said, well, it was copied precisely so that the programmers of Android could use something with which they were familiar, but also because it was intuitive, it was purely functional, and that what this would allow was it would allow other programmers to be able to work well with Android, which they determined was a useful purpose. But then they also looked at the fact that this was a use on a new platform, meaning smartphones. So it was only copied to the extent that it was useful for smartphones and necessary for programs to speak to each other. Again, this is one that a lot of lawyers are a little hesitant about, because basically what the court is saying in this is that derivative works aren't given as much protection. So this was a little bit of a surprise to all of us here. But that what the current one says is that if it's more transformative, it's going to lean more towards fair use. They did also say, and I think that, and this one we've seen before and is very common, if it's common in the industry, then you're going to lean more towards fair use in this. If the purpose and character is to swap ideas and create innovation and create equal things within the industry, it is going to be seen more favorably as far as that goes. So the court determined that this weighed for fair use. Amount and substantiality. Sorry, I'm speeding up a little bit just because I see that we're nearing the end. So we look at this one um, for how much was taken compared to what was taken at the beginning. So here it was 37 total packages or 11,500 lines of code. If you look at the declaring code in isolation, it was virtually the entire declaring code. That's a lot as far as amount goes. But if you look at the entire API, it was only 0.4%. This is one of those places where sometimes a jury can be really helpful as far as what is most important in this circumstance. And part of what they looked at here was, well, was the declaring code really the heart of the work? The answer was no. The declaring code is basically just very useful. Kind of went back to the purpose and character argument, which you're not really supposed to do, but sometimes with that heart of the work, it makes a difference. If this were the heart of the work, if this were the creative point, if this were the thing that were important for Android to function, it might have turned out differently. Let me use an example. How many of you have heard bum, 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 bum? It's 4 bars of music in a 40-minute long symphony. That's not very substantial in size, but it is the most identifiable part of Beethoven's Fifth Symphony. I can use it because that's in the common good at this point. There is no copyright protection at this part. Very identifiable. Even someone like me can sing that and have people recognize it, I hope. But that's what we're talking about when we get to heart of the work, is sometimes if it's really important to the work, the small part doesn't matter. So what they looked at was, well, it's all of the declaring code, but really a small part of the API in total for both. And sometimes they'll go back and forth with which one they compare it to, but that it's really that implementing code that's the heart of the work. This is just a functional part. So that weighed for fair use. And then finally, the effect on the potential market. This is also one that a lot of copyright attorneys are not really thrilled with the way that this came out. Usually what we look at for this is it a market substitute or a market driver? Easy example for this, if somebody is selling bootlegged copies of a Disney movie on the street corner in China, that means that people are not then going to the store and buying the appropriately licensed one, which means that Disney is losing out on its royalty. We call that a market substitute. Market drivers are something like somebody saw the parody Spaceballs and they decided that it was so funny. Man, I just haven't watched Star Wars in a long time. I'm going to go back and watch that. That would be a market driver. And you have various things on various ones of those. But loss of revenue is not everything. And I will tell you, they almost entirely will scrap this element in criticism cases. So if somebody is doing a book review or a concert review, and there happens to be some copywriting to show how bad something is, they don't care that it's going to kill a show. It is still a worthwhile value that's written in the statute. So oftentimes, if it's one of those situations, we'll kill this factor. However, a lot of times it is a very useful factor. And in this case, obviously, we're looking at market substitute or market driver. Another thing they look at is public benefit versus individual protection on this. Think like the COVID vaccines. They rush those ones out. There's not really the normal patent process. Why? Because there's a giant public health scare. So sometimes there will be that consideration for this factor as well. Here, I will tell you that even though we're not a fan of how they determined this, basically that Oracle wasn't going to be in the smartphone space, because technically licensing should function with that. I will almost guarantee you that they decided this factor on Google's side because the Oracle executives testified they actually thought this would benefit the company. And this is one of those situations of you kind of look at it in a vacuum and you say, was this the right decision? And that really, I think the key factor here was that Oracle itself said, no, actually, I don't think this will hurt us. I think this will help us. If you're going to do that, you're going to lose those other issues. We say sometimes bad facts make bad law. And I think on this particular factor, that was the case. So then the court balances it And the determination by the court was that Google's copying was fair use. So I'm very sorry, I can't remember who guessed that, but guessed wrong, as did many of us. But not all of us. It was a good split as far as that goes, and the jury in California certainly determined that Google's copying was fair use. Again, I think the testimony weighed heavily on that determination. Um, but really quickly, just as far as what is the effect of that going forward, is that they have officially affirmed, the Supreme Court officially affirmed that fair use is now a mixed question of fact and law. Technically, that's not new. Technically, that was done in 1985. However, at that point, they were making a determination on a bench trial, meaning it was judges all the way up. Um, and that's just not quite as strong as far as that goes. You saw in this case, even the jury made a decision on that. What a mixed question of fact and law means is that the jury determines who's credible and what the findings of facts are, and then the judge determines what they mean. The Supreme Court determined that doing that with fair use is not a constitutional violation, which is consistent with past law as far as that goes. It is a defense, and it is an interpretation of a strict statute. But it is a little bit sad because you saw how much all of this is balancing factors. And a lot of times with these things, there are a lot of technical expertise. And so there is that aspect of it, that impact on it. Just going to switch up just really quickly. I talked about the criticisms as we went. Just wanted to point out that part of this is what the case doesn't say, that we can kind of read behind the scenes on this. Oracle's really well known for being very aggressive against unlicensed users of Java SE, and that this might have some big impact on some of those licenses. It also doesn't really talk about the split between the Java language and Java SE for programming and the potential impact on programmers, or the application that this would have had on the current effect of the Android market. But I can tell you that these were all being considered as this was going. It was also interesting that this was written by Justice Breyer, because Breyer is well known for disliking a lot of these copyright protections and thinking more things should be out in the public market. And, you know, it also is, a lot of people are saying, well, they didn't answer the copyrightability question because they didn't like it. And so they just skipped straight to the fair use, and that was really the issue there. So those are some of those behind the scenes things going on with this case. What does this mean for you, us going forward? Is declaring code copyrightable? Probably. We know software is still copyrightable. Isn't this just similar to thin protection like a phone book? It really seems so. It's not very clear. We can't say that for certain, that if one of you goes forward on a thin protection situation, that we would be able to use this case favorably, or we shouldn't use this case, but it does seem so. Should you change your processes with fair use based on this case? You know, I always say you probably shouldn't assume you have fair use anyway. We said you should always get the permission if you can, but you should consider that you will be facing a judge on this issue and not a jury. That you can't necessarily count on just people understanding your industry or the way things work or the way programming works, or that you might be harmed by the fact that people don't know the way that your industry works. But otherwise, this really has limited applicability in the world of software, so they say. I think this will actually be applied to a lot of other things within copyright. So if you're in those fields, if you're in the architectural engineering fields, do be aware of that. I'm sorry, I've gone a couple of minutes over time, but I am happy to stick around and answer some questions if people have them. And if not, then John can always send out the recording, like he said, to those of you who aren't able to finish up with us here.
Yeah, absolutely. There's a few questions if you do have a moment, Sam.
Awesome. Yeah.
So Jackie, who lost the wager. Sorry, Jackie.
Sorry, Jackie.
She says, I use pictures and blogs. If I saw an image on Google and then use it as inspiration and create my own image, is this infringement? Is this fair use? Where does that fall?
That's a great question. That's a long-standing question as to how much is inspiration copying. And that's where you have to look at that access and substantial similarity question. You definitely had the access if you saw it. So then that question is substantial similarity. If you're doing a colored pencil drawing of a direct image that you saw on Google, that's going to be infringement. If you just really like the pose that somebody took and you do a cartoon drawing with a similar pose, but the people look entirely different, background looks entirely different, that's going to be a little bit more attenuated. It's really hard to give very lump answers for questions like that. It is always a sliding scale, but do keep in mind that access plus substantial similarity. How much are you actually using it for inspiration versus how much are you direct copying?
Next, Olga wants to clarify when you said that fair use was a defense to infringement. So she writes, if you prove the fair use, you will not be considered violating the copyrights, as in no punishment.
Correct. No punishment is what that means. So it is a complete defense if you have it, meaning that you will not be subject to those statutory fines and damages.
Deborah has a very interesting question.
Okay.
How does all this relate to translation of literary works or other copyrighted material? Is there a particular process for obtaining permission?
Awesome. Translation is one of those six. I didn't actually list it. I just listed the usual three, but translation, transliteration is one of those six protections. If you're looking at doing translation of literary works, typically you want to go to the copyright holder. So copyright.gov is the US copyright site. You can typically look up copyright, see who the holder of those things is, whether it's the publisher, the author. Oftentimes they'll have contact information for licensing, and you can reach out to them through that. If you're looking at more academic works, oftentimes it's easier to contact the school or the journal themselves as far as that goes. While we're talking about it, if you're looking at music licensing, most of those are handled by a couple of big organizations that you want to reach out to on that. Very few musicians do their own licensing. They're typically part of licensing networks. Worst comes to worst, if you like the work, reach out to the author if they're still alive, and just ask them what the process is, and usually they can put you in touch with who you need to be put in touch with.
Wonderful, wonderful. All right. Well, thank you everyone for your participation and the questions. Really appreciate it. We did go over time, but I know this was high value, so hopefully your time was well spent here. Remember, you can always find us at northmetrosbdc.com, find out more programs coming up, and you can book free appointments with our consultants. And you had Samantha's information there as well. You can visit lawpolaris.com and find out all about the offerings at Polaris Law Firm. So, wow, Sam, thanks so much. I learned a ton. I really appreciate it. And it's always great to have you on. So thanks for coming by.
Absolutely. Thank you, John. Thank you, guys.